All right, let's talk about what just happened, because this situation between Blake Lively and Justin Baldoni has taken yet another serious turn. And this time, it could extend the legal battle much longer than anyone expected. As you already know, Blake Lively's lawsuit against Justin Baldoni is currently moving through federal court in New York. That case centers around her allegations of sexual harassment and retaliation connected to the production of It Ends With Us. Baldoni denied those allegations and previously responded with a massive countersuit, one that targeted not only Lively but also Ryan Reynolds and the New York Times, accusing them of defamation and reputational harm. Earlier this year, that countersuit was dismissed by a judge, but now a new filing in New York State Court confirms that Baldoni and the Wayfarer Studios parties are preparing to appeal that dismissal to the Second Circuit, and that changes everything. The original suit was thrown out largely on procedural grounds. The judge ruled that certain claims could not move forward under applicable legal protections, including anti-SLAPP laws designed to prevent retaliatory lawsuits in response to protected speech. Importantly, the dismissal did not involve a full trial on the merits of Baldoni's evidence. Instead, it focused on whether the lawsuit itself was legally viable in that form. At the time, Baldoni's team was given the opportunity to amend parts of their complaint, to revise and strengthen specific claims. They chose not to. Instead, they preserved their ability to appeal the entire dismissal. Now we know why. By formally notifying the court of their intent to appeal, Baldoni and the Wayfarer parties are signaling that they want the Second Circuit to review whether the case should have been dismissed at all. If the appellate court agrees with them, the dismissed claims could potentially be revived, and if that happens, discovery could reopen. That means more documents, more internal communications, more depositions, and possibly more public scrutiny of everyone involved, including Blake Lively, Ryan Reynolds, and the media organizations named in the original countersuit. There's another layer to this. The New York Times, which published a December 2024 investigative piece detailing allegations and internal communications related to the case, is also seeking legal fees tied to the dismissed lawsuit, arguing that it falls under anti-SLAPP protections. Baldoni's team is now asking the court to delay any ruling on those fee requests until the appeal process plays out. Their argument is simple. If the dismissal is overturned, the Times would once again be an active defendant in the revived case, so awarding fees now could be premature. Appeals to the Second Circuit can take months, often anywhere from 3 to 9 months before a decision is reached. That means even if Blake Lively's primary lawsuit moves toward trial or resolution, this parallel legal fight could stretch well beyond it. And in Hollywood, time is not neutral. Extended litigation affects reputations, projects, endorsements, and industry relationships. Studios are cautious, brands are cautious, and prolonged courtroom battles tend to create uncertainty. What's especially significant here is that an appeal does not allow Baldoni's side to introduce new evidence. The appellate judges will review the existing record and determine whether the lower court made a legal error in dismissing the case. So this becomes a technical, high-stakes legal argument about interpretation of law, not a fresh presentation of dramatic new material. Still, if the appeal succeeds, the door reopens to deeper scrutiny and a potentially much broader legal fight. For Blake Lively and Ryan Reynolds, this means the legal exposure may not shrink anytime soon. For Baldoni and Wayfarer, it's a strategic gamble, one that suggests they believe the dismissal was incorrect and worth challenging at a higher level. At this point, one thing is clear. This dispute is far from over. What started as a conflict surrounding a film adaptation has evolved into one of the most complex and closely watched legal battles in Hollywood today. And with an appeal now officially in motion, the next chapter won't be written quietly.
Now here's where the broader implications start to come into focus, because this appeal isn't just a procedural step, it's a pressure point. When Justin Baldoni and the Wayfarer Studios parties decided not to amend their complaint after the dismissal, that was a calculated move. If they had amended and lost again, their ability to appeal would have been significantly limited. By standing on the original filing, they preserved their right to challenge the entire dismissal at the appellate level. That suggests long-term strategy rather than retreat, and in high-profile litigation, strategy often matters as much as evidence. If the Second Circuit determines that the lower court made a legal error, the countersuit could be reinstated. That would mean the claims against Blake Lively, Ryan Reynolds, and the New York Times could move forward again. And if that happens, discovery would likely reopen, not just defensive discovery, but potentially expansive investigative discovery. That phase can be intense. Attorneys request emails, text messages, internal communications, PR strategies, financial records, anything relevant to the claims. In a case this public, those materials often end up shaping public perception as much as courtroom arguments. It's important to understand the stakes for each side. Blake Lively's original federal lawsuit alleges sexual harassment and retaliation. Those are serious allegations that carry legal and reputational weight. Baldoni has firmly denied them. His countersuit alleged that he and his company were defamed and intentionally damaged through coordinated narratives, including media coverage. The New York Times December 2024 investigative article became a major focal point in that dispute. The Times has defended its reporting and is now seeking legal fees under anti-SLAPP protections, arguing the countersuit targeted protected journalistic activity. If the appeal succeeds and the countersuit is revived, the Times could again become an active defendant. That's why Baldoni's team is asking the court to hold off on awarding legal fees until the appellate court rules. It's a tactical move. Pause everything until we know whether the case is truly over. There's also the financial dimension. Appeals are expensive. Extended litigation is expensive. Legal teams at this level involve high-powered firms billing at extraordinary rates. And beyond legal fees, there's the opportunity cost. Projects get delayed, partnerships get reconsidered, studios factor risk into casting decisions. Even when no verdict has been reached, prolonged legal uncertainty can quietly influence careers. Ryan Reynolds' involvement adds another layer. As one of Hollywood's most bankable actors and producers, his name being tied to a defamation countersuit, even a dismissed one, brings heightened attention. If the countersuit is revived, his role would again be examined in detail. That increases media scrutiny and industry conversation. At the same time, it's worth noting that appeals courts rarely overturn dismissals in media-related cases unless there's a clear legal misinterpretation. Anti-SLAPP protections are strong, particularly when journalism is involved. That makes this appeal an uphill battle. But uphill does not mean impossible. Appellate courts exist precisely to correct lower court errors, and Baldoni's team appears confident enough to pursue that path rather than walk away. So what we're seeing now is not a cooling of tensions, it's a structural escalation. One lawsuit continues forward, a dismissed countersuit moves toward appeal, fee disputes remain unresolved, and the possibility of renewed discovery hangs over everyone involved. This isn't just a celebrity dispute anymore. It's a layered legal conflict involving employment law, defamation law, anti-SLAPP statutes, media protections, and high-stakes reputation management. And as long as the appeal remains active, the narrative is still evolving inside the courtroom, not just on social media.
What makes this final layer of the story so significant is that it reshapes the timeline entirely. Even if Blake Lively's federal case against Justin Baldoni moves toward trial or settlement, the appeal process could keep the broader conflict alive well beyond that outcome. Appeals don't move quickly. Briefs are filed, responses are submitted, oral arguments may be scheduled, and then judges deliberate. Months can pass in near silence, and then a single ruling can reopen everything. If the Second Circuit upholds the dismissal, Baldoni's countersuit effectively ends at that level, barring a rare further appeal. That would solidify the lower court's interpretation of anti-SLAPP protections and close the door on those defamation claims. But if the appellate court reverses the decision, even partially, the legal battlefield expands again. Claims could be reinstated, discovery could resume, depositions could take place under oath, internal communications across multiple parties, including PR teams, executives, and possibly media personnel, could be examined in greater depth. That possibility alone changes the leverage dynamic on both sides.
For Blake Lively, the focus remains on her original allegations of harassment and retaliation tied to the production of It Ends With Us. Those claims are independent of the countersuit, but the public narrative inevitably intertwines them. If Baldoni's appeal were to succeed, it would create parallel legal tracks moving at once, one centered on workplace conduct, the other on defamation and alleged reputational harm. That kind of dual litigation can become extraordinarily complex. For Justin Baldoni and Wayfarer Studios, the appeal signals a refusal to let the dismissal stand uncontested. Strategically, it communicates confidence in their legal argument, that the case should have been heard on its merits rather than dismissed at the threshold. Appeals are not emotional reactions, they are calculated legal maneuvers. The decision not to amend earlier and instead preserve appellate rights now looks deliberate. Then there's the media dimension. The New York Times' reporting in late 2024 became a central flashpoint. The publication has defended its work and sought recovery of legal fees under anti-SLAPP statutes. If the dismissal stands, that strengthens the paper's position. If it's overturned, the legal exposure returns. Media organizations watch cases like this closely because appellate rulings can shape how far investigative reporting protections extend when high-profile figures claim reputational harm. Beyond the legal arguments, the broader entertainment industry is paying attention. Studios evaluate risk carefully. Long-running litigation creates uncertainty, even when no liability has been established. Careers in Hollywood often move at the speed of perception as much as verdict. Projects are greenlit based on bankability, public image, and predictability. When high-profile names are entangled in ongoing court battles, that calculation becomes more complicated. At this stage, there are no final answers, only procedural steps that will determine the next phase. The appeal to the Second Circuit ensures that this story does not conclude with a single dismissal order. It becomes a test of legal interpretation, strategy, endurance, and narrative control. And until the appellate court speaks, both sides remain in motion. This entire situation began with a film adaptation meant to bring a best-selling novel to the screen. Instead, it has evolved into one of the most closely watched legal conflicts in recent Hollywood history, involving allegations of misconduct, claims of defamation, media scrutiny, and now an appellate challenge that could reshape everything again. That's where things stand right now. If you've been following this case, you already know it rarely stays quiet for long. Make sure you're subscribed, stay informed, and I'll continue breaking down every major development as it happens.